Be seated. Stay ready.
Yes, Judge. My name's Chandler Rain, and along with my co-counsel, Ms. Kira Kilday, we represent the state of Lone Star. And before we begin, Judge, we do have some housekeeping matters, as well as some motions to make outside the presence of the jury.
We'll take these up. Get the appearances. Get the defense ready.
Yes, Your Honor. My name is Kia Scott, and today with my co-counsel, Elliot Smith, we are Team C, and we represent the defendant, Sean Appleby, in this case. We too have housekeeping matters and motions in limine whenever Your Honor is ready.
All right. We'll be seated, and we'll take up the state's motions first.
Yes, Judge. Just by way of giving you a little bit of background about this case, this is a murder case arising from an incident that occurred at the home of the victim, a man by the name of Mr. Tom Lawson. Mr. Lawson had a party at his home and had invited the members of his company over to the home. One of those members was the defendant, Mr. Sean Appleby. Another one of the partygoers was a man by the name of Drew Roberts. And Mr. Roberts is the focus of our first motion in limine. We anticipate that the defense is going to try and elicit testimony about Mr. Roberts' temper, or Mr. Roberts' propensity to get into arguments, as well as his employment history and being fired from a previous job. This particular type of evidence is improper character evidence under Rule 404, as it doesn't go to show this witness's character for truthfulness or untruthfulness, only this witness's character to have a bad temper. And because of that, it should be inadmissible.
Bunce?
Your Honor, the defense does not plan to use his previous termination in this case, so we do not have a problem with that being excluded.
So what do you ask the court to do?
Your Honor, you may grant the motion in limine.
I'll grant your motion.
And second, Judge, there's an individual by the name of Ted Nasters who was not one of these partygoers. We anticipate that the defense is going to try and elicit testimony about Mr. Nasters' work history as well. Mr. Nasters was a police officer with the Dallas Police Department and was terminated from that job for police brutality. This also is improper character evidence under Rule 404, as it doesn't, again, go to show his character for truthfulness or untruthfulness, only his propensity to commit a violent act. And because of that, it should be inadmissible.
Your Honor, again, we will be mentioning Ted Nasters, but we will not be discussing his previous termination. So we do not have a problem with that being admitted or the court granting the motion.
Mr. Grant?
And nothing further from the state, Judge.
Thank you. Counsel, you have a motion?
At this time, Your Honor, would you like to hear housekeeping, or would you like to take up motions in limine for the defense?
Your Honor, at this time we have two motions in limine. The first is we believe the evidence in this case will show that there was an FBI investigation into DigiWorks Company, which is the company that Sean Appleby works for, as well as the deceased in this case. We believe that evidence will come through emails or testimony on behalf of the detective in this case, and we ask that the court exclude any mention to this investigation under 403. It's inadmissible because it would be highly prejudicial for the jury to hear this, anything about this investigation. There have been no crimes charged, no federal crimes have been mentioned to be brought against the defendant, and furthermore, Your Honor, the investigation is not even an ongoing investigation. Also, it would be confusing to the jury to hear of this investigation.
So you want any evidence or mention of what was essentially a preceding and almost parallel investigation by the FBI to be excluded?
Yes, Your Honor, that is correct.
Or at least not offered into evidence without prior ruling from the court at that time?
Your Honor, we would ask that the court rule on this in motions in limine that it be excluded, but if you choose to reserve your ruling, we would ask that they be prohibited from using it in opening statements.
Bunce?
Judge, the prejudicial value that comes from the emails and the investigation is farly outweighed by the probative value here. It's part of the state's theory that the defendant saw these emails and learned about the investigation, and that went to the motive of the defendant on the night of July 4th. And because of that motive, its probative value is farly outweighs the prejudicial value of these emails and the investigation, so it should be admitted.
Yeah, I'm going to grant the motion in limine, but it's qualified. It's not a final ruling. We'll hear the evidence, and I'll look at where we are in the trial and the context at that time. Relevant evidence to the murder, it can be very highly prejudicial, depending on what we mean by prejudicial, of course. I would think the state always hopes that its evidence is prejudicial in the relevant sense, but we can make that judgment at that time. But let's not go into it without bringing it up again. And so that my ruling is that the limine motion is granted, but subject to reconsideration at the appropriate time when you get to that point.
Certainly, Judge.
All right. Anything further?
Yes, Your Honor. We have one more motion in limine. We would like the court to exclude any use of the term murder weapon. Your Honor, we have not conceded that a murder took place in this case. It is our theory that an accident was just as likely. Furthermore, it'd be highly prejudicial for the jury to hear it referred to as a murder weapon. As Your Honor, that is a fact that is still in dispute.
Judge, the term murder goes directly to the charge in this case. The word murder weapon is going to allow all of the witnesses, specifically the detective, the lead detective in this particular case, to identify which weapon was used in this crime that he investigated. And so the term murder weapon will allow the jury actually to be able to understand the difference between items that were found and tagged and the actual murder weapon. So this would be relevant under 404.
I'll deny the motion. I think the jury understands that the characterization of this particular piece of equipment, which I understand is a device for lifting the leaves out of a pool, they'll understand that that characterization is the state's characterization. So I don't think that's necessary to try to exclude that and draw that line so thin. So I'll deny that motion.
Yes, Your Honor. That will conclude our motions in limine. My co-counsel, Kia Scott, does have a few housekeeping matters before we get started, whenever Your Honor is ready.
Sure.
Thank you.
Yes.
First, Your Honor, just a few items of efficiency before we begin today's trial. May we assume that all witnesses have been pre-sworn?
I'm sorry?
May we assume that all witnesses have been pre-sworn, Your Honor?
Yes.
Also, Your Honor, can we constructively invoke the rule of witness sequestration for all parties except for the defendant today?
Objection to that? Take none?
No objection to that, Judge.
You may.
May we also assume that all sidebars are constructive today, Your Honor?
Yes, you may.
Your Honor, also, would you like us to ask the first time or every time before approaching a witness?
No, I think you can approach the witness in the natural order of things. If you abuse the practice, I'll let you know.
Also, Your Honor, would you like to see any exhibits before they are handed to the witness today?
Not necessary.
Your Honor, would you like us to ask the first time or every time before having to approach the bench?
You need not, if you'll ask before you approach the bench at any time, but it's not, I would think that it will not be necessary to do so ordinarily.
Also, Your Honor, would you like to see any demonstratives as they are presented to the jury today?
No.
Can counsel move freely about the well during speeches and examinations today?
Yes.
Now, Your Honor, we would like to clarify a few things that we've stipulated with opposing counsel. We will be using an enlargement today. We've shown opposing counsel this enlargement, and they have agreed that it is what it purports to be. Also, Your Honor, we would just like to remind the court that pursuant to the local rules, we are required to call the defendant to the stand today. And also, Your Honor, we would like to remind the court that we are operating under the federal rules of evidence and the federal rules of criminal procedure. And we would like to ask court permission to refer to the rules of this competition as the local rules. That concludes all of our housekeeping matters for at this time, Your Honor, and we're ready to proceed when the court is ready.
One thing to all counsel, keep your voice up, and I'll promise to do the same. I will also tell you to speak slowly, that is not rapidly. If you can manage that, it will be very helpful to me, if not to the jury. I've found that these courtrooms lose their acoustical power each year. So you may proceed.
Yes, Your Honor.
State's ready for opening statements.
You may.
May you please court? Lying, backstabbing, snitch. Those are the words of that man, Sean Appleby, a man so filled with resentment and rage, he got his revenge by picking up an 8-foot-long metal pole and cracking it over the neck of his friend and colleague, murdering him. Members of the jury, my name is Kira Kilday, and along with my co-counsel, Chandler Rain, we have the honor of representing the state of Lone Star against Sean Appleby. We have charged him with the offense of murder. Every day, the defendant would arrive to work at DigiWorks, where he's second in charge. He works for his friend, someone he's known since high school, and someone who turned out to be the victim in today's case. The victim had founded the company about 5 years ago. But the defendant feels like it's his idea. He's not getting credit for it. Regardless, the victim got to be the boss, and the defendant resents him for it. On the 4th of July, the victim hosts his annual 4th of July barbecue, and everybody from the company is there. There's the marketing director, Drew Roberts, the bookkeeper, Bobby Vasquez, the defendant, and the victim. The evening was fine, good eats, good drinks, good visits. But the evidence will show that at some point, the defendant goes inside the victim's house. He stays in there for 20 minutes alone. And when he comes back out, he's different. He's changed. Something in that house caused all those years of resentment to morph into rage. He starts arguing with the victim, and he waits for everyone else at the party to leave. And now, he will get his revenge. The defendant tows his way over to the side of the house where the victim keeps his pool cleaning equipment. He bends down to pick up one of those pool cleaning poles, and he tows his way over, creeps up behind the victim who has his back turned. He cocks the pool pole back, and he swings as hard as he can. Years of resentment, years of being second best, rage, all released in one swing of a pool stick. A swing hard enough to fracture the back of the victim's neck. Hard enough to knock the victim unconscious into the pool with a splash. Members of the jury, today, we as the state have the burden of proving to you beyond a reasonable doubt that that defendant intentionally and knowingly took the life of the victim, Tom Lawson, in this case. Now, proof beyond a reasonable doubt is not proof beyond any and all doubt. It's just when the evidence leaves you firmly convinced. And at the end of this trial today, my co-counsel, Mr. Rain, is going to come up here and spell it out for you using the evidence and testimony you will hear today. Now, you're going to hear from someone who was at that party, the marketing director, Drew Roberts. Now, Drew Roberts also went to high school with the victim and the defendant, so he'll be able to tell you just how much the defendant resented the victim for the lack of credit he got at the company. And he was also at that party on the 4th of July, so he'll be able to tell you how the defendant was fine, how he was calm, but then he went inside the house, and when he came back, he was different. He was in a foul mood, and he started arguing with the victim. Drew Roberts, ready to go, left, leaving only the defendant alone with the victim. Now, you're also going to hear from the lead investigator in this case, Detective Stacy Wortham. Detective Wortham's going to describe for you the scene as he originally found it, diagrammed it, photographed it, the evidence he collected from that pool cleaning pole, the defendant's fingerprints found on it. But he'll also be able to tell you about the defendant's rage, how he interviewed the defendant twice. And on that second time, the defendant was fine, he was calm, but then at some point, he changed. He went from calling the victim his brother to saying he could rot in hell because he was a lying, backstabbing snitch. So that's why, at the end of this trial and after the conclusion of all the evidence and testimony today, I'm confident you will know that you will be firmly convinced beyond a reasonable doubt that that defendant should be found guilty of murder. Thank you.
Your Honor, the defense would ask for a brief moment to set up the courtroom. Your Honor, the defense is ready to proceed. May it please the court. Opposing counsel. $11 p.m. to 8 a.m. Unexplained, unaccounted for, unknown. 9 hours unexplained. That's 540 minutes unaccounted for. 32,000 seconds of unknown. Members of the jury, that is too much unknown time to convict Sean Appleby for this crime. Good afternoon. My name is Kia Scott, and today, along with my co-counsel, Elliott Smith, we have the privilege of representing Sean Appleby. I'd like to take just a minute to introduce you to Sean Appleby. Could you stand for me, Sean? This is Sean Appleby. He's a longtime resident of Bexar County. He grew up and graduated right here in Lone Star. And after finishing college, after receiving a phone, he started a career after finishing college, but after receiving a phone call, he left the only career he knew and started a company with his best friend, Tom Lawson. Now, without even having the opportunity to grieve the loss of his best friend, Sean Appleby is being dragged into court, accused of murder by the prosecution. But in the state of Lone Star, the prosecution can't just accuse a person of murder. They've got to prove it. And as the prosecution has told you today, they do bear the burden. They not only have to prove it, but they must prove it beyond a reasonable doubt. Beyond a reasonable doubt. And let me tell you, that's a high burden. It's the highest burden in our American justice system, and it should be if the prosecution wants to take a man's freedom away. Beyond a reasonable doubt. That simply means that at the close of today's trial, if there are questions or there are holes, there are possibilities, and the prosecution has yet to explain those possibilities, answer those questions, or fill those holes, members of the jury, that is reasonable doubt. Now, I want to tell you something because this is important. At this moment, as it stands, Sean Appleby is presumed innocent until the prosecution can prove him guilty beyond a reasonable doubt. So, what does that mean exactly? Let me give you an example. That means that if we were to stop this trial right here, right now, you'd have no choice but to return a verdict in his favor, because at this moment, Sean Appleby is cloaked in a presumption of innocence. And at the close of today's trial, you'll see that the prosecution won't be able to meet its burden. The prosecution won't even be able to touch that cloak because Sean Appleby is innocent. He did not commit any crime. Now, the evidence today will show you 4 things. The first thing that the evidence will show is that Sean Appleby attended a 4th of July barbecue at his best friend's home. You'll hear from Bobby Vasquez that the food was grilling, the drinks were flowing, and everybody had a great time. You'll hear from Sean Appleby that after he left that party at 11 o'clock p.m., he went home, had a good night's rest, and when he woke the next morning, he received the news that his best friend had passed away in the night. Now, as the prosecution mentioned, Sean Appleby was not the only party goer that day. There were 3 other attendees at the party. Those partygoers included Tom Lawson, Drew Roberts, and Bobby Vasquez. But you see, no one would have been surprised to see these 4 together. They were great friends, grew up and graduated together. And as the prosecution pointed out, they started a business together, DigiWorks Incorporated. Each of them had a different function in management at the company. Tom Lawson functioned as CEO. Now, Sean Appleby was CFO of that company. Drew Roberts, Drew Roberts was head of marketing. And Bobby Vasquez kept the books. Now, the second thing that the evidence will show you today is that everyone at that party had the same opportunity and means to hurt Tom Lawson that day. The third thing that the evidence will show you today, you haven't heard. You see, the prosecution just came before you and told you a really good, exciting story. But what the prosecution didn't tell you is that there was possibly a 5th person at the party that night. His identity has been confirmed through DNA evidence. Today we know him to be Ted Nasters. And you'll learn when Detective Wortham takes this stand today that Ted Nasters sat outside the Lawson house for hours the night of that barbecue. You see, what took place when Ted Nasters went into the backyard of Tom Lawson's house? We don't know, because the prosecution knows that the lead detective on this case has yet to be able to question him because they can't locate him, can't find him. And that's important. Now, the fourth thing that the evidence will show you today is that the night of that 4th of July party, Tom Lawson had a blood alcohol level of a 0.19. And members of the jury, that is double the legal limit. And despite knowing this, the lead investigator never checked the possibility of an accident. So, members of the jury, whether or not Tom Lawson slipped, hit his head, and fell in his pool, accidentally causing his own death, that information, it's unaccounted for. And whether or not any of the other partygoers that night had anything to do with Tom Lawson's death, it's unexplained. And what happened when Ted Nasters entered Tom Lawson's backyard after all the partygoers left? Members of the jury, it's unknown. No one who takes this stand today will be able to conclusively tell you what happened to Tom Lawson from 11 o'clock p.m. when the last partygoer left his home and 8 o'clock a.m. when his body was found the next morning. That's 9 hours 32,000 seconds of unknown. Members of the jury, that is too much unknown time to convict Sean Appleby for this crime. And that is why at the end of today's trial, my co-counsel, Elliott Smith, he'll come back before you today and ask you to return a verdict of not guilty. At this time, Your Honor, we would ask to preserve the board for closing statements.
Would the bench like to see the demonstrative that was wrong?
State calls Mr. Drew Roberts.
Hello, Mr. Roberts. You've been previously sworn.
Mr. Roberts, could you introduce yourself to the members of the jury?
Hi, my name is Drew Roberts.
And where are you from, Mr. Roberts?
I'm from right here in San Antonio, Lone Star.
What do you do for a living?
I'm in charge of marketing at DigiWorks.
Marketing at DigiWorks.
Yes, sir.
What do you do in your role as marketing director?
Well, essentially what I do is I conduct a lot of market research, a lot of surveys. I look at our community, find out what problems they have, and try and come up with solutions to those problems.
So let's talk about a little bit about the company that you work for, DigiWorks. When was that company founded?
It was founded about 5 years ago, a little over 5 years ago today.
And who founded the company?
Well, Tom Lawson founded the company, but around the company, Sean always kind of felt like he founded it as well, kind of resented the fact that Tom founded it.
Mr. Roberts, tell the members of the jury a little bit about what DigiWorks does.
Well, essentially, we handle financial investments for customers involved in digital technology.
And who worked at DigiWorks?
Well, Tom Lawson, who was the CEO, Sean Appleby, who was the CFO but is now the CEO, Bobby Vasquez, the bookkeeper, and myself, marketing director.
You mentioned Mr. Appleby. Do you recognize Mr. Appleby in the courtroom today?
Yes, sir, I do.
Could you identify him with an article of clothing that he's wearing?
Yes, sir. Mr. Appleby is sitting right over there, wearing a black suit and a red tie.
Your Honor, please let the record reflect that Mr. Roberts has identified the defendant as Sean Appleby. Mr. Roberts, you've mentioned 4 members at DigiWorks. Was it unusual for the 4 of you to do things together?
No, I mean, the 4 of us have known each other since high school. We would get together every now and then, and in fact, every Independence Day, July 4th, we would get together at Tom's house. He hosted an annual party, just the 4 of us.
Let's talk about one of those parties. Where were you on July 4th of 2013?
I was at Tom's house. He was hosting his annual 4th of July party for the 4 of us.
And who was there that day?
Tom, the host, Sean, myself, and Bobby Vasquez.
Where was Mr. Lawson's wife that day?
Well, usually she was there for our 4th of July get-togethers, but this past year, she unfortunately couldn't be with us. Her father was suffering from cancer, and so she had to be in Chicago to be with him.
So what were you all doing on the 4th, Mr. Roberts?
We were having a party. We were eating, barbecue, drinking. We were swimming in Mr. Lawson's pool, just having a good time.
Were you all inside of Mr. Lawson's house? Were you outside?
No, we were mostly in Mr. Lawson's or Tom's backyard, in his patio area most of the night.
Could you describe the backyard for the members of the jury?
I could, but being a marketing director, I'm much more visual. I could draw it out for the jury if you would like me to.
Your Honor, permission to have the witness step down for the purposes of a demonstrative.
Down.
Mr. Roberts, you can go ahead and step out this way. I'm going to hand you this blue pen, and if you would draw this backyard for the members of the jury.
Okay, so...
One moment, Mr. Roberts.
Step around, counsel.
Thank you, Your Honor.
No,
you're fine. If you could go ahead and draw the backyard for the members of the jury.
Sure. So Tom's house was on the south side of the backyard. And he had 2 doors leading into his house on the left and the right on the south side. then his backyard, which was to the north, was surrounded by 3 fences, one on the left, one on the top, and then one on the right.
Now, Mr. Roberts, before we keep going, I know we pulled you away from the mic and we have a court reporter. If you would just go and be sure to keep your voice up so that she's able to hear you.
Yes, sir.
Now, is this Mr. Lawson's front yard or backyard?
This is his backyard.
Would you go ahead and mark in the top left corner B for backyard? Were you all just sort of roaming around in the backyard, or was there somewhere specific that you spent the night?
No, we were mostly in Tom's patio area where he had a table. That would be on the left side of his backyard. I can go ahead and draw that in.
That'd be perfect.
So it'd be here on the left side. And then his patio table was in the middle of that with 4 chairs where the 4 of us would sit and talk.
Now, what were you all doing in this patio area?
Oh, we were talking, drinking. We had some beer, we had some wine, champagne.
So you were drinking alcohol.
Yes, sir.
Could you mark this patio area with an A for alcohol?
Sure.
Mr. Roberts, what else were you all doing in Mr. Lawson's backyard?
Well, Tom had a pretty nice sized pool, so we were swimming in it for a while.
Could you draw this pool on here?
Sure, so the pool was to the right side of Tom's patio table, so it would be here on the right.
And could you mark that with a P for pool for the record?
Yes.
Mr. Roberts, who, if anyone, did you see clean this pool on the night of the 4th?
Tom did. Tom cleaned his pool about 10 o'clock. He loved that pool. He liked keeping it clean.
And what did Mr. Lawson use to clean that pool?
He used he had 2 pool poles, and he happened to use his blue one.
And where would those pool poles be on your diagram?
So Tom always kept his pool equipment between the 2 front doors going inside of his house. He always kept it out of the way. And in fact, after he cleaned the pool, he put it back there again. Just doesn't want anyone to trip over it.
Could you draw where that pool equipment would have been?
Yes.
And could you mark that with a PE for pool equipment?
Yes.
Excuse me, Your Honor. Objection. I'd like to ask that counsel, to preserve the record, that they spell out the words rather than the mere abbreviations. I believe that they are leading to spelling the defendant's name with the letters that they're using.
I think we can handle P and E so far.
Thank you, Judge. Mr. Roberts, we're going to go ahead and continue. Now, did you spend the entire time at Mr. Lawson's house in the backyard?
No, so after swimming, we would change. So before we would eat, we would go into Mr. Lawson's house, use his restroom, get out of the swimming trunks.
And what, if anything, did you see while you were inside Mr. Lawson's home?
Well, I happened to see Tom's laptop. It was inside his house, in the kitchen area, on. I could see the screensaver.
And did you have a password to that computer?
I did, and so did Sean.
Now, why did Mr. Lawson give you the password to the computer?
Well, God forbid anything happened to him. He wanted one of us to be able to have access to it. He had business stuff on there for DigiWorks.
You mentioned that that laptop was inside. Could you draw an L for laptop inside Mr. Lawson's home?
Sure.
Mr. Roberts, did you see anyone else go into Mr. Lawson's home on the 4th?
Yes, Sean did.
About how long was the defendant inside Mr. Lawson's home?
Well, it was kind of unusual because most of us would just be in and out changing. Sean was in there for about 20 minutes.
And what was the defendant's demeanor like when he came back out?
Well, he went in a good mood. We were all in a good mood, having a party. When he came back out, he seemed to be in a foul mood.
What do you mean by a foul mood?
Something changed about him. He seemed angry.
Okay. Mr. Roberts, what time did you leave Mr. Lawson's party?
I left at 11 o'clock, 15 minutes after Bobby left.
And who was there when you left Mr. Lawson's?
Just Sean and Tom.
Were they having a discussion? Did you hear the defendant say anything to Mr. Lawson before you left?
Yes. Both appeared pretty upset. There was some yelling. Sean said something to Tom about keeping sensitive emails on the computer.
And where was that on your diagram?
It would be here to the right of the pool.
Could you mark that with a Y for yelling? You can take a seat, Mr. Roberts. Your Honor, permission to preserve the demonstrative for use in closing. Mr. Roberts, you mentioned that the defendant had said something about emails. How did Mr. Lawson respond to that?
Tom was really upset and really angry.
When you left on the night of 4th of July, what was Mr. Lawson doing?
He was having an argument with Sean. He was angry.
Pass the witness, Judge.
Cross-examination. Mr. Roberts, you work at DigiWorks, correct?
Yes, sir. I'm in charge of marketing at DigiWorks.
That's right. You're the actual marketing manager at the company.
Yes, sir. I'm in charge of marketing.
And before Tom Lawson's death, he was the CEO?
Yes. Tom was the CEO.
So you guys had to work together closely on a regular basis?
I would say so, yes.
And sometimes you had to discuss business like marketing activities?
Of course. Tom was in charge. I was in charge of marketing, so yes, of course.
And you guys disagreed about how to market the company?
We did. We both were strong-minded, and we did have our disagreements.
Strong-minded. He wanted to market in Mexico?
Yes, Mexico and Canada.
But you were adamant about staying stateside.
Yes, I believed it was better to market in the U.S. for a few years more.
And in one of those arguments, you actually told Tom Lawson that he would live to regret his
Objection, Judge.
decision.
May we approach? May we approach, Judge?
What's your objection?
The defense is getting into testimony about Mr. Roberts and having an argument with Mr. Lawson and threatening Mr. Lawson, but that was dealt with in the state's first motion in limine about Mr. Roberts' propensity to have arguments with his employers. The defense themselves said that they weren't going to be getting into this testimony, and yet they're doing it right now.
Response, Your Honor. The motion in limine was made in regards to Drew Roberts' previous testimony, and I believe I said I did not have a problem as long as that was not mentioned. We are talking about his current employment.
Overrule the objection. Let you continue.
Thank you, Your Honor. Now, in one of those arguments, Mr. Roberts, you told him, Tom Lawson, that he would live to regret his decision.
Yeah, we always disagreed. Almost all of our arguments ended in something like, you'll live to regret your choice.
Now, I'd like to talk to you about the 4th of July.
Okay.
You were at Tom's house?
I was.
You were there with Bobby Vasquez?
Yes, Bobby Vasquez, Tom, and Sean were there.
The four of you were hanging out?
Yes.
You were eating?
We were eating, we were drinking, we were having a good time. Yes.
Having a good time. It was a party.
It was.
But throughout the entire night, Sean didn't stay outside the entire time, did he?
No, as I mentioned, he went inside.
But you didn't stay outside the entire time either.
No, we all went inside to change.
In fact, Tom Lawson left his house unlocked the entire evening.
Well, when we were there to go in, yes, it was, the doors were open.
And everybody went in and out of the house at some point that night.
Yes.
And when you went inside, you went in to use the bathroom?
Yes.
You went in to change?
To change, get out of my swimming trunks.
But you also went into Tom Lawson's kitchen.
Yes, I had to pass his kitchen area.
And when you were in his kitchen, you saw Tom Lawson's computer.
Yes, it was on in plain view.
You saw it was sitting on his kitchen counter.
Yes.
And you even noticed that it was on, and you noticed the particular screensaver that made up his background, did you?
Yes, I did.
Now, just to clarify, you were inside alone with that computer.
Yes.
And you do have the password to that computer?
Yeah, as I mentioned earlier, Tom gave me and Sean the password.
Now, I'd like to talk to you a little bit about the outside of Tom's house. Tom Lawson, at some point, got up from the patio table where you guys were eating and drinking to clean some leaves out of his pool.
Yes, he did that at about 10 o'clock, if I remember correctly.
He grabbed the pool pole that was on the side of his house.
Yes, the blue pool pole.
And he used it to get the leaves out.
That's correct.
And then he returned it.
Exactly.
And when you left that night, it was lying next to his house?
Yes, when I left, both of his pool poles were, as I drew in the diagram, between his two doors.
But now, just to clarify, Tom cleaned those leaves out because he was particular about his pool, correct?
Yes, that's just the way Tom was.
He liked to keep it neat and clean.
That's correct.
Now, I'd also like to talk to you about one last individual. When you left the house at night, You went to get in your car, correct?
Yes, I did, to leave.
And you saw your car was out on the street.
That's correct.
You saw Sean Appleby's car was out on the street.
Yes.
But you also saw a car you didn't recognize.
Yeah, a dark-colored car.
And you noticed that somebody was sitting in that car.
Yes, there was a man inside.
And they were smoking cigarettes.
He was smoking a cigarette, yes. There was only one.
And the person in the car was smoking a cigarette.
Yes.
And when you left Tom's house that night, that individual was still sitting on the side of the street.
Well, he was in his car, yes, when I left.
No further questions, Your Honor.
Just briefly, Judge. Mr. Roberts, when you left Mr. Lawson's home, who was there?
Just Tom and Sean.
No further questions, Judge.
Step in.
Your Honor, before the state calls its next witness, the state would like to offer State's Exhibit 1, 2, 3, 4, and 5. Permission to approach the bench?
Yes, you'll hand up a copy, please.
Just to walk you through, State's Exhibit 1 is the medical examiner's death certificate. State's Exhibit 2 is the medical examiner's autopsy report. State's Exhibit 3 is the forensic report prepared by the crime laboratory here in Bexar County. All three of these come with an affidavit from the custodian of record, and all three of these meet the hearsay exception under 803-6. State's Exhibit 4 and 5 are the defendant's own written statements and fall under the admission by party opponent exception to the hearsay rule.
Yes, Your Honor. At this time, we would only object to one piece of evidence, and that would be the medical examination report.
Medical examiner's autopsy report.
Yes, Your Honor. Our objection would be improper opinion. We'd like to turn the court's attention to the probable cause or manner of death paragraph. If you will read that, Your Honor. I'm sorry, Your Honor. May we approach?
Just tell me what you want to look at.
If you read that, Your Honor, you will see that the medical examiner in this particular instance did not give an objective opinion as to what caused any bruising on Tom Lawson's body or how that bruising could have occurred. It is more of a narrative statement, and it is not an objective opinion. And since the medical examiner is not here today to be able to testify as to how this particular opinion was drawn, we would say that it is substantially more prejudicial than it is probative and would confuse the jury under 403.
You're referring to the entry under probable cause, manner of death?
Yes, Your Honor. That would be correct.
It's during the regular course of business and practice of this medical examiner to examine wounds found on body and to use their knowledge as to how those wounds were obtained on the body. This was part of the medical examiner's duty, and they were only, it was only in furtherance of that duty that they completed this medical examiner's report.
The opinion they might come forward with, if done in the quote, course of their duties, is going to be admissible without any underlying expertise?
I will only be eliciting testimony through Detective Wortham as to how he used the medical examiner's report in his subsequent investigation.
Your Honor, a brief response?
Yes.
We do not object to the entire medical examiner's opinion, Your Honor. We're only objecting to that particular portion of the opinion. We would ask that a redacted version be given to the detective.
Which read me precisely what you object to under that probable cause, manner of death statement.
Under probable cause or manner of death? It is under probable cause.
No, objection's overruled.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Detective Stacy Wortham. I am a police officer with the San Antonio Police Department.
How are you involved in this case, Detective Wortham?
I was the first respondent on the scene, and then I became the lead investigator in this case.
Just to talk about your background a little bit, where'd you go to school?
I graduated from the University of Houston. While I was there, I studied history, but I also got a minor degree in criminal justice studies.
How long have you been a detective with the SAPD?
I've been a member of the SAPD for going on, I guess it's 8 years now. I have investigated 25 homicides during that time, and I've been a homicide investigator for, I guess, going on 5 years now.
What kind of special training did you receive to help you investigate homicides?
Well, like every police officer, I went through the police academy. But in addition to that, after I became a homicide investigator, I began to receive special forensic investigation courses. Now, those are conducted by the Federal Bureau of Investigation at their headquarters in Quantico, Virginia. So for the last 4 years, I've been doing those.
When did you first become involved in the Tom Lawson murder investigation?
I first became involved on the morning of July 5th, 2013. There was a 911 call made by one of Mr. Lawson's neighbors. The 911 dispatcher directed me to go to Mr. Lawson's residence, so I did.
And where was that residence located?
It was 1245 Whisper Willow.
What county is that in?
It's located in Bexar County.
Please describe the scene when you first got there.
Well, when I got there were a couple of neighbors in the front yard, and when I pulled up, they directed me to the backyard, saying that the body and the pool were located there. I followed their directions, went into the backyard, where I discovered the body in the pool, like they described. There were also a few neighbors standing in the backyard. They appeared to be upset, probably by the sight of the body. One of them was crying.
Did you check for signs of life or attempt to resuscitate the body?
No, I did not.
Why not?
Well, the body had been in the pool since the next door neighbor made the phone call. When I observed the body, it had sunk to the bottom of the pool. It was clear that there was no oxygen in the body. I didn't check for signs of life.
So what did you do when you first got to the scene?
I directed my attention to preserving evidence. Took photographs, diagrammed the scene, looked for relevant pieces of evidence.
Tendering to opposing counsel what's been marked as State's Exhibit 6 through 11. Permission to approach? Permission to approach Detective Wortham? Detective, I've just handed you what's been marked as State's Exhibit 6 through 11. Please take a moment to review those and then look up at me when you're done. Are all of those fair and accurate representations of the scene that you diagrammed and photographed?
Yes, they are.
State offers State's Exhibit 6 through 11.
Just a moment, Your Honor. We have no objections.
Permitted.
The state has prepared exact enlargements of State's Exhibit 6 through 11. Permission to publish those for the jury and to have Detective Wortham come off the stand to aid in his testimony. 1 second, Detective. Now, if you wouldn't mind just stepping right here in between these two easels. Now, first we're going to look at State's Exhibit 6. What are we looking at here in State's Exhibit 6?
This is a diagram I prepared of the scene. It's not done to scale, but it does a good job of showing the relationship and the placement of the different objects that I found.
All right. Now, I want to start on the far west side of this diagram, but you mark street, and then work our way through the backyard just like you did, all right? Now, what's the first thing we would see when we walked into Mr. Lawson's backyard?
When I entered Mr. Lawson's backyard from the street here on the bottom left corner of State's Exhibit 6, I discovered a patio table.
And you photographed that patio table.
Yes, I did.
Here in State's Exhibit 7, what are we looking at here, Detective?
This is the photograph that I took of the patio. As you can see, there are a couple of empty liquor bottles on the table, 5 to be exact. There's a bottle of Knob Creek, which is a type of whiskey. There's also a bottle of Bacardi, which is a type of rum. There's some white wine and some champagne as well. There's also a completely empty bottle of Diet Coke.
And moving on through the backyard, what's the next thing that we would see on our right in the backyard?
I saw Mr. Lawson's pool cleaning equipment, or one pool cleaning pole specifically.
This is State's Exhibit 8. What are we looking at here?
This is a photograph I took of the pool cleaning pole that was lying next to Mr. Lawson's house.
What are these pool poles typically used for?
They're typically used for cleaning leaves and other debris out of pools.
Where's the net on this pole to use it for cleaning?
As you can see in this exhibit, in State's Exhibit 8, the net for this pole is actually detached from the pole.
How could it have been used to clean if it was detached from the pole?
Well, in this condition, it could not have been. It would have had to have been assembled. Someone would have had to take the net, screw and attach it onto the end of the pole before it could be used.
Now, moving on through the backyard, just there around the corner, what's there?
On the bottom right corner, State's Exhibit 6, you'll see a cigarette butt that I found.
You photographed that as well.
Yes, I did.
This is State's Exhibit 9. What are we looking at here in State's Exhibit 9?
State's Exhibit 9 is a photograph I took of that cigarette butt. It was located at Mr. Lawson's side yard in some gravel.
And what'd you do with the cigarette butt?
I took that cigarette butt and I placed it in a bag. I sent that to the forensic laboratory for DNA testing.
All right, now, Mr. Rain has that forensic lab report. It's been admitted as State's Exhibit 3. Whose DNA belonged on the cigarette as concluded by the crime lab?
The crime lab found that a man named Mr. Ted Naster's DNA was located on the cigarette butt.
When was when was the DNA left there, though?
That they couldn't tell us. DNA doesn't come with a timestamp, unfortunately.
All right, and you've already mentioned what was in the middle of the backyard. What would we find there in the pool?
In the middle of the backyard, there was, of course, the pool with the victim's body.
This is State's Exhibit 10. What are we looking at in State's Exhibit 10?
State's Exhibit 10 is the photograph I took of Mr. Lawson's body.
All right, now Mr. Rain has the medical examiner's autopsy report. What did the medical examiner conclude to be the probable cause or manner of death?
The medical examiner said this: the probable cause, manner of death was the decedent was rendered unconscious and drowned after being struck on the back of the neck/head by a hard object appearing to be tubular in structure. And there's a diagram indicating where that was.
What do we see that's tubular in structure close to the body?
As you can see in State's Exhibit 10, there's a long metal pool pole lying very close to the body.
You photographed that as well. What are we looking at in State's Exhibit 11?
This is a close-up photograph I took of that pool pole that was found near Mr. Lawson's body.
What evidence, if any, did you recover from this pool cleaning pole?
We took the pool cleaning pole to the forensic laboratory, and they ran fingerprint tests.
And that would be included in the forensic lab report that's in State's Exhibit 3. Mr. Rain's going to hand it to you. Whose fingerprints did the forensic lab find on this pool cleaning pole?
The forensic lab found the fingerprints of Mr. Tom Lawson, the owner of the home and the pole, but they also found the fingerprints of Mr. Sean Appleby on that pole.
Where else, if anywhere, what other evidence did you recover from the scene?
We also gathered an ASUS laptop from Mr. Lawson's home. It was his laptop.
What evidence was recovered from that ASUS laptop?
We also tested the laptop for fingerprints.
And whose fingerprints were found on that laptop?
Like the pool pole, we found the fingerprints of Mr. Lawson, which was not surprising because it was his laptop. But we also found the fingerprints of Mr. Sean Appleby on that laptop.
Do you see Mr. Sean Appleby here in the courtroom today?
I do.
Do you mind identifying him and a piece of clothing that he's wearing?
Yes, I can. He's seated right there at the defense table. He's wearing a white shirt and a red tie and a dark black watch.
Let the record reflect that the witness has identified the defendant, Sean Appleby, in the courtroom. Thank you, Detective Wortham. Your Honor, before we proceed with Detective Wortham's testimony, we anticipate that we're going to get into an area that you actually granted a motion in limine, and we would urge you to consider the ruling that you made outside of the presence of the jury, of course. In particular, we would like Detective Wortham to testify about the emails that he found on the laptop computer These emails were included in the forensic lab report. It says that the password was obtained from Drew Roberts, that the crime laboratory located emails and then printed them out and gave them to Detective Wortham. These emails have been in his continual custodial care since being handed to him, and he will testify to how he used those emails in his subsequent investigation.
Yes, Your Honor. We would object on 3 grounds: speculation, hearsay, and relevance. Your Honor, it is speculative at best that the defendant ever saw these emails prior to July the 5th, Your Honor. Beyond that, the emails are, may we approach, Your Honor?
No, you speak from there.
Constructive sidebar. It is also, Your Honor, these emails are hearsay because Your Honor, these emails are between Tom Lawson and an FBI investigator. They are for a secondary investigation that is completely unrelated to the case at hand. It would be highly prejudicial for the jury to hear of that particular investigation. We would remind the court that that investigation is no longer in existence, Your Honor, and there were no charges ever filed. For that reason, Your Honor, they would be irrelevant, and we would say that any mention of that investigation or those potential implications would be highly prejudicial to them.
They're not speculative. They were in evidence and they were shown to the defendant. Furthermore, they are highly relevant because, as Drew Roberts has already testified to, on the night of July 4th, the defendant went inside the victim's house for some time, and when he exited, he began arguing with the victim about keeping sensitive emails on his computer. These emails, being extremely sensitive in nature, would seem that would go to the weight of the evidence rather than the admissibility of it. Furthermore, they're not hearsay because the state is not offering them for the truth of the matter asserted, whether or not charges were filed for the FBI investigation. We're merely offering them for the effect that they had on the reader.
Objections overruled. Proceed.
What else did the crime lab recover from that laptop?
The crime lab recovered several emails sent between Mr. Tom Lawson and an FBI investigator, Agent Young.
Tendering to opposing counsel what's been marked as State's Exhibit 12. Detective, I've just handed you what's been marked as State's Exhibit 12. What is State's Exhibit 12?
State's Exhibit 12 is the printout of the email chain between Mr. Lawson and Agent Young.
Are they a true and accurate representation of those emails you received from the crime lab?
Yes, they are.
State offers State's Exhibit 12.
No objection at this time.
Proceed.
So, when did you interview the defendant?
I interviewed the defendant on July 29th and July 5th.
Please describe his demeanor at the beginning of his second interview.
Well, he seemed relatively calm at the beginning of his second interview. Seemed like he was putting on a good face, and then he referred to Mr. Lawson as his brother, said that he loved him.
And then, what would he have read in those emails when you showed them to him?
Well, one particular line stands out. It's in the first email sent on June 29th. It says, this was Mr. Lawson writing. It says, "I want what is best for the company, and Appleby and Roberts are dead to me." And that statement was made in the context that Mr. Lawson had agreed to testify against Mr. Appleby and Mr. Roberts in an FBI investigation.
Please describe the defendant after he read that message.
Well, he became quite upset.
Describe quite upset for the jury, please.
Well, specifically the words that stand out were, he said that Mr. Lawson deserved to rot in hell for writing these things, and he called him a lying, backstabbing snitch.
Pass the witness.
Your Honor, a brief moment to set up the courtroom.
Right.
Your Honor, we're ready to proceed. Good afternoon, Detective Wortham.
Good afternoon.
You've been a member of the San Antonio Police Department now for 7 years,
That's right.
and you've been a homicide detective for 4 of those years.
Yes, going on 5.
I'm sorry?
Going on 5.
And according to your testimony, you've obviously been properly trained,
I would like to think so.
and you do your job well. You do a thorough investigation.
I do the best I can.
Now, you happen to be the lead detective in the investigation into Tom Lawson's death.
I was.
Now, Detective Wortham, evidence is important. You would agree.
I would agree to that.
And evidence is important because evidence helps us to determine the facts in a case.
That's one of the reasons it's important, yes.
Now, as you mentioned, you took the liberty of preserving the location of evidence in this case.
I'm not sure what you mean.
You created a sketch.
Yes, I did.
Let the record reflect that I'm showing the witness what's already been entered into evidence as State's Exhibit 5. Now, this is the sketch that you drew on the morning of July 5th.
Yes, it is.
It shows or depicts what you consider to be the scene on that morning, Detective.
Yes, it's not perfect, but it does give you an idea of where the key things were located in relation to each other.
And you also collected a large amount of evidence from the scene.
I gathered some evidence from the scene, yes.
I'd like to talk to you about some of that evidence in relation to its location.
All right.
Let the record reflect that I'm showing opposing counsel what's already been entered into evidence, Your Honor. As State's Exhibits 7, State's Exhibit 6, State's Exhibit 8,
This is actually 11. It's Exhibit 11.
For preservation of the record, Your Honor, that would be State's Exhibit 7, State's Exhibit 11, State's Exhibit 8, and State's Exhibit 9.
Yes, ma'am.
Your Honor, would you like a... Now, Detective, it's your testimony that Tom Lawson was struck on the back of the neck.
That's what we concluded, yes.
And according to your testimony, he was struck with something that was tubular.
According to the medical examiner's report, he was struck with something hard and tubular in structure.
That's correct, Detective, tubular and hard. And according to your testimony, that hard tubular object was the pole that was lying beside his body when you arrived on the scene.
That's what I concluded.
But Detective Wortham, that wasn't the only round or tubular hard thing that you found on the scene that day.
No, it was not.
Particularly, I'd like to turn your attention to what's already been entered into evidence as State's Exhibit 7.
I'm not sure if I have that in front of me.
That's okay.
To which exhibit are you referring exactly? Oh, got it.
Now, Detective Wortham, State's Exhibit 7 is a picture of a patio table in Tom Lawson's backyard.
Yes, it is.
And you drew that patio table here in your sketch.
I did.
Let the record reflect that the witness is referring to the circle that is to the left-hand side of the pool with 4 circles around it labeled patio. And this patio table was at this angle from the body.
I'm not entirely sure what you mean by this angle, but it was,
Well, from here to here.
yes, on the diagram.
Now, some of the items on this table, as you mentioned, are alcoholic beverages, Detective.
Yes, they are.
But Detective, some of these bottles too are tubular and hard.
They are.
Your Honor, permission to post or publish to the jury as needed? For instance, let's discuss the champagne bottle.
All right.
At least the neck of this particular bottle, Detective, is tubular,
That's correct. Part of the champagne bottle is.
and it is hard.
It is glass. It would be prone to shatter if it were to strike something. But yes, it is tubular.
Perhaps this would be prone to shatter, but there were things on the scene that day that weren't prone to shatter, Detective. For instance, I'd like to turn your attention to State's Exhibit 11. Do you have a copy?
Yes, I do.
Now, State's Exhibit 11 is a picture of the pool pole that you found on the scene that day.
Yes, it is.
And it is depicted here in your sketch?
That's right, near the victim's body.
That is correct, near the victim's, or Tom Lawson's body. Now, let the record reflect that the witness is referring to the perpendicular line labeled pool pole within the sketch. Now, Detective, although this is a picture of that pole, it is also a fair and accurate depiction of the edge of Tom Lawson's pool.
You can see the pool edge in this photo, yes.
Now, Detective Wortham, the edge of Tom Lawson's pool is also round in nature.
It is curved.
It's curved in nature.
Yes, it is.
Also, it's concrete. This
It is.
would be hard,
It is stone, yes, it's hard.
and there would be no shattering.
No, it would not.
Detective, now I'd like to turn your attention to what's already been entered into evidence as State's Exhibit 8.
I have that here.
Now, State's Exhibit 8 is a secondary pool pole that you found on the scene on July 5th.
Yes, it is.
And as you've testified, it's depicted here in your sketch.
That's right, on the side of Mr. Lawson's house.
Now, let the record reflect that the witness is referring to the horizontal line at the bottom of the sketch labeled pool equipment. Now, this particular pool pole, Detective, of all the items that we've discussed, is definitely tubular in nature.
That's right, it's very similar to the other pool pole.
It is very similar to the other pool pole, and it's also hard.
It is. It is also attached to a blue apparatus that seems to be somewhat heavy.
Now, with the exception of the edge of this particular pool pole, it is too hard and tubular in nature.
Right, except for the fact that it's attached to that blue apparatus, it is very similar.
So just for clarification purposes, that would be a yes, Detective. They're
Yes,
similar.
it is similar to the extent that I indicated.
But Detective Wortham, this pool pole, the bottles on the table, the edge of Tom Lawson's pool, none of these items were tested.
That is right.
They were not tested for hair,
No, they were not.
not tested for any type of DNA evidence.
I should clarify, they weren't tested for hair beyond just physical observation. We didn't see any hair on the pool edge or these pool poles.
Beyond physical observation, none of these items were ever sent to any type of testing with your forensics team.
That's right.
But Detective Wortham, you did collect some DNA evidence.
We did, from the cigarette butts.
Precisely. I'd like to turn your attention to what's already been entered into to evidence as State's Exhibit 9.
I have that in front of me.
You do have a copy? Now, State's Exhibit 9 is a picture of a cigarette butt.
It is a picture of a cigarette butt.
And that cigarette butt you collected, or is depicted on your sketch right here, Detective.
That's right, the bottom right.
Let the record reflect that the witness is referring to a small circular bush-like object at one of the entrance and exit points in Tom Lawson's backyard labeled cigarette butt. Now, Detective Wortham, you sent this cigarette and some others off for testing,
Yes, I did.
and that testing came back with results.
Did.
And you now know that the DNA on this cigarette butt and some of the others belong to Ted Nasters.
That's right, it did.
And you're aware that Ted Nasters sat outside Tom Lawson's house for some time.
I'm not certain about that, but I do know his DNA was found on the cigarette butts.
Now, you found multiple cigarette butts outside the front of Tom Lawson's home.
Yes, I did.
So common sense would tell us that it would take some time to smoke multiple cigarettes.
Well, either that or someone dumped an ashtray out of the car. Like I said, I don't know how long he was there, but I do know his cigarette butts were found at the scene.
Detective, that would be a possibility. That would be a yes.
I'm sorry, could you repeat the question?
It would be a possibility that someone could take time to smoke that many cigarettes.
It's not impossible, no.
But to date, you've not been able to contact Ted Nasters.
That's right.
You've not been able to identify him. Or excuse me, not been able to interview him.
That's right.
You can't even locate him.
That's correct.
But Detective Wortham, at one point, you named Ted Nasters as a material witness at the start of your investigation.
That's right. We thought it would have been helpful to be able to talk with him, figure out exactly what he was doing there, if anything, he observed. But no, we could not find him. We looked for him, though.
But I'd like to talk to you about other persons of interest in your investigation. Ted Nasters was not the only other persons of interest at the start of your investigation.
That's right. We considered everyone who was at the party.
And one of those individuals was Drew Roberts.
Yes.
And you're aware that Drew Roberts had arguments frequently with Tom Lawson in the office.
I have been told that, yes.
And you're also aware that Drew Roberts had the password to Tom Lawson's computer.
Objection, hearsay. This is only based on hearsay that the detective knows. If I have permission to make an offer of proof, I can indicate that he only has a hearsay basis of knowledge for Ted Nasters' password.
Brief moment to respond, Your Honor. Your Honor, we're not offering whether or not Drew Roberts had the password for the truth of the matter that he had the password, but for the effect that that information should have had on Detective Wortham.
Could you repeat your question?
Sure, I'll ask my question again. You are aware that Drew Roberts had the password to Tom Lawson's computer.
Yes, he told me that.
In fact, he actually supplied you with the password during your investigation.
Yes, I think he supplied it directly to the forensic lab, but he gave it to the police, yes.
Well, to your investigative team, that would be a yes.
That's right.
And it was also Drew Roberts who showed back up on the scene the morning of July 5th
Yes, I met Drew Roberts on the scene July 5th.
during your investigation.
While I was there looking at the house, that's right.
Now, I'd like to move forward just to a possibility, Detective. You're aware that Tom Lawson had been drinking the night of July 4th, 2013.
The autopsy report and testimony so indicated.
As a matter of fact, Detective, it indicated that his blood alcohol level was a .19.
That's what the autopsy report says.
He'd been drinking quite a bit.
It seems so, yes.
As a 7-year veteran with the San Antonio Police Department, Detective, I'm sure you're aware that a .19 is more than double the legal limit.
It's double the legal limit for driving, but as far as I'm aware, there's not a legal limit for sitting at your house.
So that would be a yes,
For driving, yes.
double the legal limit.
For driving.
Now, Detective Wortham, as a 7-year veteran with the San Antonio Police Department, unfortunately, I'm sure that you've been around intoxicated individuals.
I have been around my share of intoxicated individuals.
And sometimes, I'm sure you're aware that when individuals are intoxicated, they lose motor skills.
Some do. Some people are surprisingly adept.
Some do lose motor skills. That would be a yes.
Just some do, yes.
And some slur their speech.
Yes, some do.
Some have a tendency to stumble.
Yes, that is true.
Some even fall.
Yes,
And when an individual falls, he or she could hurt themselves,
it's not impossible.
cause bruising, for instance.
Yes.
I'd like to ask you one more thing. You talked with opposing counsel about a statement that the defendant made during your investigation when he came in to speak with you.
Yes, I believe I remember what you're referring to.
Was that statement made before or after you showed him a series of emails?
It was made in response to the emails from the FBI, between the FBI and Mr. Lawson.
No further questions for this witness.
May I proceed? Detective, what evidence, if any, indicated that Ted Nasters even knew the victim?
We were not able to find him.
What evidence, if any, indicated that Ted Nasters had any motive in this case?
We could find none.
And were Drew Roberts' fingerprints found anywhere on that scene?
No, they were not.
Who were the only person whose fingerprints were found on the murder weapon?
Mr. Appleby's.
And who were the only person whose fingerprints were found on that laptop?
Mr. Appleby's.
Last witness.
Ms. Stendo? See.
Judge, the state has no further witnesses and rests. Would also ask the court for an accounting of time.
I'm sorry.
We would also ask the court for an accounting of time.
Prosecution has 22 minutes and 8 seconds left, and the defense has 25 minutes and 4 seconds left.
State rests.
Your Honor, at this time, the defense would like to move for a motion of a judgment of acquittal. The state has failed to provide sufficient evidence to prove the elements of murder that Sean Appleby either knowingly or intentionally took the life of Tom Lawson.
The state has presented enough evidence for a reasonable juror to find that the defendant intentionally and knowingly took the life of Tom Lawson in this case. Namely, Drew Roberts took the stand and testified today that the defendant exited the house and was in a foul mood, was extremely angry, and started arguing with the victim about keeping sensitive emails on his computer. Secondly, Detective Wortham took the stand and testified to those sensitive emails and testified to the rage the defendant felt towards the victim in this case. Therefore, a reasonable juror could find the defendant guilty of murder.
Do you have any evidence of motive?
The motive being that in those emails, the victim, in this case, was going to serve as an FBI informant. And the defendant understood that to mean that he was a lying, backstabbing snitch. And the motive in this case would be to remove that lying, backstabbing snitch and his ability to testify against him.
Motion to overrule.
Yes, Your Honor.
Proceed.
Your Honor, at this time, the defense is ready to proceed with their case in chief.
Yeah.
Your Honor, we would call Bobby Vasquez to the stand.
You've been previously sworn, Ms. Vasquez. Correct?
Could you please introduce yourself to the jury?
My name is Bobby Vasquez.
And Mrs. Vasquez, did you know Tom Lawson?
Yes, I did.
Do you know Sean Appleby?
Yes, I do.
And do you know Drew Roberts?
Yes.
How do you know these three individuals?
Well, we currently work together as part of DigiWorks.
Now, you mentioned that you work together, but before we get into your work relationship, I'd like to talk to you specifically about the nature of your relationship with these three. Did you know them outside of work?
Yes, we've actually been friends ever since we were in high school. We graduated from Reagan High School together, and even though we parted our separate ways for a little while, Tom actually brought us back together to work together at DigiWorks.
How did you come to work at DigiWorks?
Tom approached me and asked me to with the others.
And all three, who else worked with you at DigiWorks?
Well, there was myself, Drew Roberts, Sean Appleby, and of course, Tom Lawson.
Now, Mrs. Vasquez, do you attend the annual 4th of July parties at Tom Lawson's house?
Yes, I do.
Were you at the party in 2013?
Yes, I was.
Can you describe the atmosphere of that party?
Well, I got there a little late, but when I got there, the party was in full swing. Everyone was eating, drinking, socializing, just having a good time. It was a very casual, fun atmosphere.
Anything unusual, out of the ordinary for the four of you?
Not that I saw.
Now, Mrs. Vasquez, I'd like to talk to you about the party the year prior to that in 2012. Did you attend the 2012 party?
I did.
Can you describe that atmosphere?
It was very much the same as it was in 2013, just casual and fun.
Could you compare the 2012 to the 2013 party for the court?
They were the same. Really, it was just a great opportunity for us to get together each year at Tom's house to socialize and relax outside of work.
I'd like to talk to you about one more thing, and it's kind of personal. Mrs. Vasquez, do you smoke?
I do not.
Have you ever seen Sean Appleby light a cigarette?
I have not.
Does Drew Roberts smoke?
No.
Did Tom Lawson smoke?
No.
Did anyone ever smoke at Tom Lawson's house that you were able to observe?
Absolutely not.
Was there any particular reason why there would be no smoking at Tom's house?
Yes, Tom's wife Audrey is highly allergic to cigarette smoke, so he was very adamant about people not smoking at his home.
No further questions for this witness at this time.
May I proceed?
Yes.
I want to talk to you about the evening of July 4th. You arrived to the party at 6 p.m., is that right?
Yes, that is correct.
So you got there late.
I did. I was with my mother. She's been very ill.
So the party had already started. And then you left the party early, didn't you?
I did. I needed to go be with my mother.
Around 10:45, right?
Yes.
So you were the first to leave, right?
I was.
So you don't know what happened before you got to that party, do you?
No, I do not.
And you don't know what happened at that party after you left, do you?
No, I just know that while I was there, everybody was eating, drinking, having a good time.
Thank you for your explanation, but just to clarify, you don't know what happened after you left? And you were invited to this party because it was amongst employees, right?
Yes,
The DigiWorks employees. And you're the bookkeeper at DigiWorks, right?
I am.
And DigiWorks was, at the time, experiencing some financial difficulties, right?
Yes, it was.
And unfortunately, you were experiencing some financial difficulties too, weren't you?
With regard to my mother's medical expenses, yes. But Sean was helping me out.
It was really gracious of him to help you out. He loaned you about $5,000, didn't he?
Yes, he did.
And you still owe him that money, don't you?
He has not asked me to pay him back, but I am certainly working hard to pay him back for his kindness.
So he was very kind to you, right? You
Yes.
still owe him that money, right?
Working very hard to pay him back for it, even though
And now you're here to testify for him, aren't you?
I'm here to tell the truth about what I know.
Past witness.
Brief redirect, Your Honor. Is Sean Appleby requiring you to pay any of this money back?
No, he is not. I'm doing that simply to repay him for what he's done for me.
And would you characterize this money as a gift or a loan?
It was definitely a gift, given the type of person that Sean is.
And did Sean Appleby gift you this money before or after Tom Lawson died?
Before.
No further questions, Your Honor. The witness may be excused.
You may step down. Next witness.
Your Honor, at this time, the defense calls the defendant Sean Appleby to the stand.
Come around, Mr. Appleby.
Would you introduce yourself to the jury, please?
My name is Sean Appleby.
And Mr. Appleby, what do you do for a living?
I am currently the CEO of DigiWorks.
You said DigiWorks. What is that?
DigiWorks is a company that handles real estate investment for digital clients across the country.
Did you work with Tom Lawson at that company?
Yes, sir. I worked with him for 5 years.
Now, I know this is a difficult question to be asked, but did you kill Tom Lawson?
No, sir, I did not.
Would you have any reason to kill Tom Lawson?
No, sir, I would not.
Would the company benefit in any way from his death?
No, sir, it would not. Since the company is a financial real estate-based company and Tom had all the key members to make this company run, the company would liably fall apart without him.
Now, Mr. Appleby, I'd like to talk to you about some of the statements made today. You've been in the trial throughout the course of this trial so far?
Yes, sir, I have.
And you've heard all of the testimony made?
Yes, sir, I did.
And so you heard Detective Wortham take that stand?
Yes, sir.
And he said that your prints were on the pool pole collected. How did your prints get on that pole?
About a couple of weeks before the 4th, I was at Tom Lawson's house, and we were out on his patio drinking and having a conversation, and I had cleaned some leaves out of his pool.
Now, did you touch that pool pole on July 4, 2013?
No, sir, I did not.
I'd like to talk to you about another piece of evidence that was collected by Detective Wortham.
Yes, sir.
He collected Tom Lawson's computer. Did you hear that testimony?
Yes, sir, I did.
He said that your fingerprints were on there. How did they get on that computer?
As I work with Tom, it's been times around the office that I've moved his computer around or handed it to him in meetings and things of that nature.
Now, you said you've moved it around. Will you clarify for the court what that means?
Yes, sir, just handing it to him or moving it out the way so coffee wouldn't spill on it and things of that nature. But as far as accessing it, we never accessed his computer.
Is there a reason why you would not access his computer?
Yes, Tom was very particular about his computer, and he didn't like people accessing it or looking through information on it.
Now, did you touch that computer on July 4, 2013?
No, sir, I did not.
Mr. Roberts, I'd also like to talk to you about some emails that you were shown.
Yes, sir.
Referring court and counsel to what has already been moved into evidence as the emails between Tom Lawson and the FBI. Mr. Appleby, do you know what these are?
Yes, sir, I do. There are a set of emails that Detective Wortham gave me during our interview.
And did you read the entirety of those emails?
Yes, sir, I read a good portion of them, yes, sir.
No. Did those emails implicate anybody at DigiWorks in federal crimes?
Yes, sir, it implemented me and Drew Roberts.
And you said you and Drew Roberts?
Yes, sir.
Were there multiple crimes that were being discussed?
Yes, sir, it says something about overvaluing real estate property and the value of DigiWorks.
Now, what did those emails say about Drew Roberts?
It says that the figures that were presented were given to me by Drew Roberts.
Now, I'd also like to talk to you a little bit about when you left.
Yes, sir.
Thank you. About when you left Tom Lawson's house. Were you the last to leave that night?
No, sir, I was not.
Was anybody else at that house with Tom Lawson?
Yes, sir, someone was left after I had left.
Do you remember who was there?
Not particularly. It was either Bobby or Drew, but I remember someone still being there and the party still going on.
Is there a reason why you don't remember who exactly was there?
Yes, sir, we had been drinking all day, and towards the end of the party, everything got a little fuzzy, so I really don't remember who, but I knew someone was left with Tom.
Now, lastly, I'd like to talk to you about your personal relationship with Tom Lawson.
Yes,
Can
sir.
you tell the jury about that relationship?
Me and Tom have known each other for years. We graduated high school together. We went off to different colleges, but we still kept in touch with each other. And about 5 years ago, he gave me a phone call, and he asked me to help him build his dream and to start DigiWorks, and I accepted.
And have you guys worked together for the past 5 years?
Yes, sir, we have.
Did you ever argue during your time working together?
Me and Tom were like brothers. We were family, and just like all families and all brothers, we did have disagreements. We disagreed about sports, politics, and things of that nature, and sometimes even business.
Did those disagreements ever come between you two?
No, sir, never.
Now, when was the first time that you learned of Tom Lawson's death?
I learned the day after the 4th, which was July 5th.
No further questions, Your Honor.
May I proceed, Judge? Sir, you knew Mr. Lawson since high school.
Yes, sir, we graduated together.
You all were good friends in high school.
Yes, sir, we were.
And you kept up in college.
Yeah, we stayed in contact with each other throughout our college career.
And then after college, you all started DigiWorks together.
Yes, sir, I got a phone call about 5 years ago from Tom about his dream, and I told him I would help him with it.
So you're going to help him out with his dream.
Yes, sir.
Now, at that company was Mr. Roberts,
He was.
Miss Vasquez,
He was.
and Tom Lawson.
He was.
And Tom was the CEO.
He was.
And you were the CFO.
I was.
You're the Chief Financial Officer.
I was.
You were second in charge.
We were about equal. In a corporate structure, CEOs and CFOs are on the same playing field.
I understand the nature of a corporate structure, but Chief Executive Officer is a higher title than Chief Financial Officer. You'd agree with me on that, wouldn't you?
No, I wouldn't agree with you on that.
You wouldn't agree with me on that. Okay. Now, sir, the company was your idea, wasn't it?
It wasn't my original idea. I just put some thought and my little inference in on it.
So your testimony before the members of this jury is that the company wasn't your idea.
I had the thought for the idea, but Tom was really the key person.
Now, sir, in your words, you said that you were the brains behind the company, didn't you?
Yeah, I put a lot of organization into the company, but as I said, Tom was the key person. He had all the connections we needed.
But you would agree with me that you stated previously that you were the brains behind DigiWork.
I could agree with that, yes.
Okay. Now, sir, we're going to talk a little bit about July 4th, 2013.
Okay.
You were at Mr. Lawson's home,
I was.
and the members of DigiWorks were there.
Yes, me, Tom, Bobby, and Drew.
And you all had been drinking that day.
Yeah, we drink pretty heavily, yes.
drank pretty heavily. You had too much to drink, didn't you?
I wouldn't say I had too much to drink because I drove home.
You wouldn't say that you had too much to drink.
Not too much.
So your testimony today is that you didn't have too much to drink that night.
Not too much I could drive.
May I approach the witness, Judge?
You may.
Mr. Lawson, I'm going to be referring to your previous statements. Do you remember giving statements to Detective Wortham?
Yes, sir.
Do you remember giving a statement to Detective Wortham on July 29th, 2013?
I'm pretty sure I did, yes.
You're pretty sure you did, or you did?
I did.
You did. Now, that's your name at the top of that statement, isn't it?
Yes,
July
it is.
29th. And you're giving this to Detective Wortham. And that's your signature, isn't it?
It is.
And you're verifying that you're telling the truth with that signature, aren't you?
Yeah, I mean, I have no reason to lie.
Now, if you would follow along with me on line 33
Objection,
of
Your Honor.
page
Would
30
you
of the record.
please ask counsel to refer us to the page and line number that he is directing the witness to?
Judge, I was in the middle of referring to the page and line number. Now, if we're going to look at page 30 of the record, line 33, follow along with me very closely and let me know if I mess up, okay? We all probably had too much to drink. Those are your words, aren't they?
Yeah, we probably had too much, but as I said, I didn't drink that much because I was able to drive.
Sir, did you or did you not testify previously that you had too much
Objection, Your
to
Honor.
drink?
Improper impeachment. The witness stated that they probably had. He's trying to clarify the difference between probably had and had too much. There is a difference between that, and the witness has testified to this.
May I be heard, Judge?
Overruled.
Now, sir, I'm going to ask you for the fourth time. You had too much to drink on that night, didn't you?
You can say.
I could say that, or you could say it.
You can say yes.
You've testified to that, haven't you?
Yes.
Okay. Now, you don't even remember everything that you did that night, do you?
I remember key parts of the night.
Key parts. But you told Detective Wortham that you couldn't remember everything exactly that happened that night, right?
Not everything, but the keys.
Now, you also told Detective Wortham that you must have gone into Mr. Lawson's home at some point, correct?
Yeah, I told him I probably went in to change out of my bathing suit or to use the restroom.
Probably to change. And you left the party at about 11 o'clock that night, didn't you?
I did.
And when you left, you weren't the first person to leave, right?
No, someone had left before me.
Someone had left before you. Drew Roberts had left before you, correct?
As I said in my second statement, I don't quite remember who left before me or who left after me. I just knew somebody was there after I left.
Sir, you gave a statement to Detective Wortham on July 5th, the day after Mr. Lawson was killed, didn't you?
Yes, sir. As I said in my second statement, I told the police officer I don't really remember who left before or after me.
I understand that, sir, that you gave a second statement, but my question was, you gave a statement to Detective Wortham the day after Mr. Lawson was killed, on July 5th, right?
Yes, sir. In that statement, I did say I left after Drew.
You said you left after Drew, that Drew Roberts left first. That was your testimony, wasn't it?
Yes, sir, it was.
And your testimony today is that you don't really remember.
Yes, sir, just like I said in my second statement.
A year and a half after July 4th, 2013, you don't really recall.
No, sir. I said that in my second statement.
But on July 5th, you would agree with me that you said Drew Roberts left
Objection,
first.
Your Honor. Asked and answered. Asked and answered.
Your objection is?
This question has been asked that he said on July 5th that he didn't, or excuse me, that Drew Roberts was first to leave. Your Honor, the counsel is simply asking the same question over.
May I be heard, Judge?
Go ahead.
The witness has been evasive, simply referring to his second statement, not accepting the fact of his testimony on July 5th. Certainly, Judge. No. Sir, you testified that you never saw Mr. Lawson's computer on direct examination. Is that right?
Yes, sir.
And you testified that Mr. Lawson was very protective of his computer.
He was.
And you said, and this is a quote from your direct examination, there have been times I moved his computer around or handed it to him. Is that right?
Yes, sir.
But that hasn't always been your testimony, has it?
No, like I've told the police officer, Tom told us that if we ever accessed or got on his computer, we were dead to him.
Mr. Lawson said that you would be dead to him. Is that
yes,
correct?
Yes, sir, if we accessed his computer.
And then you told Detective Wortham that you might have touched it at the office at some point, right?
Yes, sir, to move it around or out the way.
But you didn't tell Detective Wortham that, did you?
I didn't tell him an exact day, but I told him I probably moved it around in the office.
You probably touched it at some point, is that right?
Yes, sir.
And now you're telling the members of the jury in no uncertain terms, definitively, there have been times I moved his computer around or handed it to him at work. Is that right?
Yes, sir. That's probably how my fingerprints got on.
Okay. Now, sir, we're going to talk a little bit about Mr. Lawson's pool pole for just a minute. You
Okay.
testified on direct examination that you didn't touch the pool pole on July 4th, right?
No, sir, I did not.
That you touched the pool pole a couple of weeks before
Yes, sir, I did.
at Mr. Lawson's home.
Yes, sir, as me and Tom were drinking out on his patio having some conversations.
But you were here when Mr. Roberts testified, weren't you?
Yes.
And you heard Mr. Roberts testify that Mr. Lawson cleaned his pool, is that right?
Yes, he cleaned his pool on the night of July 4th.
He cleaned it at about 10 p.m., didn't he?
Yeah, that sounds probably about right.
But no one else cleaned the pool that night.
Not that I know of, no.
You didn't clean the pool that night.
No, sir.
You left at about 11 a.m. or 11 p.m.
Yes, sir.
Now, sir, we're going to talk for just a moment about your relationship with Mr. Lawson. You've told Detective Wortham previously that you loved Mr. Lawson like a brother. Is that right?
I do.
And you told Detective Wortham that Tom was like family to you.
He was just like a brother to me.
You testified on direct examination that y'all were like brothers. Is that right?
Yes, sir.
And then you told Detective Wortham that Tom was a lying, backstabbing snitch. Is that correct?
After reading the emails that he had presented to me, I did say those words.
You told Detective Wortham that you were angry with Tom.
I never said I was angry.
You never told Detective Wortham that you were angry.
In that moment, I was a little upset because we were family at DigiWorks, and to know that our CEO was turning us over and fabricating things about us kind of upset me a little bit.
I understand that,
because we were
sir.
family.
Angry, upset. They're about the same thing, aren't they?
They're close.
But you were upset.
You can say that.
You told Detective Wortham that Tom had stabbed you in the back, didn't you?
He had stabbed all of us in the back. We were family.
He stabbed all of you in the back. The whole DigiWorks family.
Me and Drew.
You and Drew. And then you told Detective Wortham that Tom deserved a rotten hell. Is that right?
As I said, I was in a moment and I was thinking about our family and how close we were, and to know that he would do something like that, I misspoke.
Sir, I understand that it was a difficult moment for you when you saw those emails, but my question was, you told Detective Wortham that Tom Lawson deserved a rotten hell. Is that right?
Yes, sir, I did.
Pass the witness, Judge.
Yes, brief redirect, Your Honor. Mr. Appleby, on July 4th, did you touch the pool pole collected in evidence?
No, sir, I did not.
On July 4th, did you see Tom Lawson's computer?
No, sir, I did not.
And were you the last to leave the party that night?
No, sir, I was not.
One last question. When did you first learn of the FBI investigation into DigiWorks?
Objection, Your Honor. Asked and answered. This question was asked on direct examination.
No rule.
I'll ask my question again, Mr. Appleby. When did you first learn of the FBI investigation into DigiWorks?
I first learned of the investigation when Detective Wortham showed me the emails from Tom Lawson to the FBI.
Thank you. Your Honor, this witness may be excused, and the defense will rest its case in chief.
Thank you, Your Honor.
The defense also rests its case in chief, and we would like to renew our motion for judgment of acquittal.
The motion's overruled.
Yes, Your Honor.
Your Honor, may we have a brief moment to prepare the courtroom before closing arguments?
Prosecution closes its evidence. Prosecution closes its evidence.
Yes, Judge.
Both sides.
may proceed, Judge. Your Honor. Now. You lying, backstabbing snitch. Members of the jury, these aren't the words of a man who loved someone like a brother. These are the words of a man who's so filled with years of resentment, who was fueled by an alcoholic rage. These are the words of a man who got his revenge. And all of the evidence and all the testimony that we've heard today, all of the reports and the photos, they only show that one man had that rage. They only show that one man had that resentment. They only show that one man had the opportunity to get that revenge. It's that man, the defendant. In just a moment, the court's going to instruct you as to the charge in this case, the charge of murder, something that we call jury instructions. The court's going to instruct you, right under subcategory 1, that our law provides that a person commits the offense of murder if he or she intentionally or knowingly causes the death of an individual or intentionally causes serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Now, the court's going to explain that instruction in the second one. The court will instruct you that a person acts intentionally or with intent with respect to a result of his or her conduct when it is his conscious objective or desire to achieve that result. The court's also going to say that a person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause that result. Now that means that when Mr. Apple showed up to Mr. Lawson's home on the night of July 4th, 2013, he didn't have to know he was going to kill Mr. Lawson. In fact, that doesn't even mean that when Mr. Apple accessed that computer and saw those emails and became upset and angry with Mr. Lawson, that he knew he was going to kill him. It doesn't even mean that when the defendant picked up an 8-foot metal pole and swung it, striking a man that he once said was his best friend in the spine, causing him to fall into a pool and drown. The law doesn't even require that at that moment he knew he was going to kill him. What the law requires is an act that's so dangerous to the human body, so serious that it can cause injury. And when you pick up that pole and you swing it, you intentionally and you knowingly commit an act that will cause serious bodily injury. And when that person dies, that is murder. The court's also going to instruct you as to what you can look at in this case. The court's going to instruct you in its fourth instruction that you may consider all relevant facts and circumstances surrounding the killing and the previous relationship existing between the defendant and Mr. Lawson, together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the offense. Now, this means that you can look to the motive of the defendant. You can look to why he did what he did. This means that you can look at everything. You can look at the emails that were recovered from Mr. Lawson's computer, emails that implicated the defendant in a federal investigation. You can look to the defendant's fingerprints on Mr. Lawson's computer. You can look to the defendant's fingerprints on the murder weapon. You can look to the statements the defendant made about keeping sensitive emails on your computer. You can look to the statements that the defendant made about Mr. Lawson. Even though it was a few days later, those are still relevant according to the laws of our state. Now, you've heard since voir dire that the burden of proof in this case is beyond a reasonable doubt, proof beyond a reasonable doubt, and that burden sits right here with the state of Lone Star. It's a burden that we're happy to take. And the court's going to instruct you as to that burden. It's very important. In its fifth instruction, the court will say that proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. And the court's going to continue that there are very few things in this world that we know with absolute certainty. And in criminal cases, The law does not require proof that overcomes every possible doubt. And that means that our burden isn't to remove all possible doubt from your mind. What the burden is that we need to remove reasonable doubt. That's when that burden is met, when all reasonable doubt has been removed. And let's talk a little bit about how we've removed that reasonable doubt, how we've met that burden. You got to hear from Detective Stacy Worth, the lead investigator in this case. And the detective took the stand and told you a little bit about his investigation. He told you about the photos that he took, the evidence that he collected, the reports that played a part in his investigation. He told you about how he was able to come to the conclusion that the defendant was the only legitimate suspect. The detective also told you about an 8-foot pool pole, a pool pole which he concluded to be the murder weapon in this case. And he took a photo of that picture, of that pool pole. And it's a pool pole that's been rendered useless for its goal. The detective told you that this pole was meant to be used to clean leaves from a pool. But there's something missing. Something missing from this pole. There's not a net on this end. There's not a net on this end. Because this pool pole wasn't being used to clean a pool. It was used to do exactly what the medical examiner's report described. It was swung with enough force that when it struck the spine of Mr. Lawson, it caused him to fall into his pool and drown as he was left there. Now, when you consider the fact that the defendant's fingerprints are on that pole, and you combine that with the other evidence the detective saw, it starts to seem reasonable why he concluded that the defendant was his suspect. See, the pool pole wasn't the only thing the detective found the defendant's fingerprints on. He found the defendant's fingerprints on an Asus laptop, a laptop that belonged to Mr. Lawson, a laptop that everyone who took that stand told you Mr. Lawson was very protective of. And the defendant's fingerprints were on it. The emails were inside of it. The detective told you that he used that information to conclude that Mr. Lawson had seen those emails, combined with the testimony that he had received. The detective took all of this information together and made his conclusion. He also got to hear from Drew Roberts. Mr. Roberts came before you and took the stand and told you a little bit about what he saw that night. He told you about seeing the defendant walk into Mr. Lawson's home for a period of 20 minutes. He told you about his demeanor when he walked out that night, how he was upset, he was angry, he was different. And then Mr. Roberts told you that he saw Mr. Lawson clean his pool and no one else. And then he left. And when he left, the defendant and the victim were arguing about emails. You also heard from the defense witness, Bobby Vasquez. And Ms. Vasquez wasn't able to tell you much, but what she was able to tell you is that when she left, the defendant was still there. And that was about it. When she was gone, Tom, Mr. Roberts, and the defendant were all there, and that's all she knew. You also heard from the defendant, and you got to hear the defendant's third story about what happened that day. It's his third story because it's constantly been changing. On July 5th, the defendant told Detective Wortham that Drew Roberts left first. He was gone first. First one to leave the party. The defendant didn't know he was a suspect. July 29th, I don't really remember who left first. Can't recall. Today, I was too drunk. I don't know what happened. His story keeps changing. Different excuses, different explanations, different people leaving. And then, when we were having a discussion about the emails and the computer, he told you that someone would be dead to Mr. Lawson if they touched his computer. That's his first story. I wouldn't touch it. Someone would be dead to Mr. Lawson. His second story, I must have touched it at work sometime. Maybe. That's what he told Detective Wortham. And then he told you today, under oath, that I know I touched that. I know I touched that laptop at work. I handed it to him at the office. I carried it to him for meetings. His story keeps changing. And what kind of man has to change his story but a guilty one? When you consider all the evidence evidence and all the testimony you've seen, the only just verdict is a verdict of guilt.
Your Honor, may defense have a moment to set up the courtroom?
You may.
Thank you. May it please the court. Counsel. Members of the jury. We have a time frame from 11 p.m. to 9 a.m. that is completely unexplained, unaccounted for, and unknown. That's 9 hours unexplained, 540 minutes unaccounted for, 32,000 seconds unknown. That is simply too much unknown time to convict Sean Appleby for this crime. 32,000 seconds of possibilities, 540 minutes of opportunity, 9 hours of reasonable doubt. There's only one thing we learned for sure today. That is that Sean Appleby did not kill Tom Lawson. He told us he left that house at 11 p.m. that night. But Tom Lawson's body wasn't found until 8 a.m. that next morning. Now, the autopsy report you saw today didn't have a time of death. It simply had a date, July 5th. There is no video evidence of that night to tell us how Tom Lawson died. There are no eyewitness testimonies to tell us what happened to Tom Lawson. Instead, what the prosecution has given us is a 9-hour window, completely unaccounted for. Now, members of the jury, that's a problem, because here in the state of Lone Star, you can't just drag someone into court and charge them with murder. You have to prove it beyond a reasonable doubt. The prosecution has the burden today. They have to give you proof from this stand, not possibilities. They have to give you substance, not speculation. They have to give you evidence, not innuendo. But think of all the possibilities. Because what we have is a 9-hour window that is completely unaccounted for. Members of the jury, I want you to imagine that it's 4 o'clock in the afternoon on a hot summer day. The food's grilling and the drinks are flowing. And on this 4th of July day, Tom Lawson's hanging out with his best friends, Sean Appleby, Drew Roberts, and Bobby Vasquez. They're eating, drinking, having a good time. 11 o'clock rolls around and they all go home. Tom Lawson, however, he stays up. He continues to drink. Continues to drink to the point where his blood alcohol content is 0.19. We know that because today we saw the autopsy report of his body. The autopsy report that told us that his blood alcohol was double the legal driving limit. Now, members of the jury, Tom Lawson, while he stayed up, continued to drink. He noticed that in his pool were some leaves. And so he did what he always does. He went and grabbed the pool pole from next to his house. And then he went to go dip it in the pool, but he realized that there was no net attached. So he turned around to get the net from the side of his house, and when he did, he slipped on the side of the pool, fell, knocked his head on the edge, knocking him unconscious into the pool where he drowned and died. Is this possible? Absolutely. Is this reasonable? Absolutely. Does the evidence support this theory? Absolutely. Members of the jury, that is reasonable doubt. Now, members of the jury, I want you to imagine it's 4 o'clock in the afternoon on a hot summer day. The food's grilling and the drinks are flowing. And on this 4th of July day, Tom Lawson's hanging out with his best friends, Bobby Vasquez, Drew Roberts, and Sean Appleby. They're eating, drinking, having a good time. 11 o'clock rolls around and they all go home. But this time, members of the jury, this time a man named Ted Nasrich has been waiting outside of Tom Lawson's house all night, waiting for everybody to leave. And when they do, he gets out of his car and he slides on his leather gloves, walks up to Tom's house, and peeks through the window to see if he's awake. And believing he's asleep, he makes his way around to the edge of to the side of the house, takes one last hit off of his cigarette and flicks it in Tom Lawson's backyard. Makes his way around to the pool where he makes a startling discovery. You see, he miscalculated. Tom Lawson was not asleep. Tom Lawson was very much awake and he was standing right next to his pool. And when Tom Lawson confronts the stranger about trespassing on his property, Ted Nasrich, in a sudden panic, picks up an 8-foot metal pool pole and smacks Tom Lawson on the back of the neck, knocking him unconscious into the pool where he drowns and dies. Is this possible? Absolutely. Is this reasonable? Absolutely. Does the evidence support this story? Absolutely. We have the cigarette print of the cigarette butt belonging to Ted Nasrich at the crime scene. Members of the jury, that is what reasonable doubt looks like. Now, members of the jury, I want you to imagine it's 4 o'clock in the afternoon on a hot summer day. The food's grilling and the drinks are flowing. And Tom Lawson's hanging out with his best friends, Bobby Vasquez, Drew Roberts, and Sean Appleby. They're eating, drinking, having a good time. 11 o'clock rolls around, they all go home. But this time, members of the jury, this time, Drew Roberts gets halfway home when he realizes that he forgot his cell phone at Tom Lawson's house. So he turns his car around to go back and get his cell phone. He gets out of his car, walks in Tom Lawson's house, and looks in the living room, doesn't see it. He looks in the dining room, doesn't see it. Makes his way into the kitchen where he spots a cell phone sitting right next to Tom Lawson's computer. And when he goes to get it, he bumps Tom Lawson's computer with his elbow, disabling the screensaver, revealing the emails between Tom Lawson and the FBI, the emails that implicate Drew Roberts in federal crimes that deal with federal time. Angered and enraged, Drew Roberts walks out the back door of Tom Lawson's house, picks up an 8-foot metal pool pole, and smacks Tom Lawson on the back of the neck, knocking him unconscious into the pool where he drowns and dies. Is this possible? Absolutely. Is this reasonable? Absolutely. Does the evidence presented today support this story? Absolutely. You saw for yourself, and you will be able to review the emails between Tom Lawson and the FBI, the emails that implicate Drew Roberts in federal crimes. Members of the jury, this is what reasonable doubt looks like. Now, Bobby Vasquez was also at that party. Bobby Vasquez was also an employee at DigiWorks. He was the bookkeeper. And these emails implicate federal crimes that deal with overvaluing property. The exact same story that applies to Drew Roberts could apply to Bobby Vasquez. That is reasonable doubt. Now, members of the jury, in just a few moments, the judge is going to give you a set of jury instructions that look very much like the ones that the prosecution showed you. And they're going to describe to you and explain to you what beyond a reasonable doubt means. But to help you in your understanding, I want to give you a story. I want you to imagine that you have a box. And in that box, you put a cat. And you put a mouse in the box. Then you put a lid on that box, and you seal it up real tight. Then you go away for a little while. And when you come back, you crack that seal, and you open that lid, and when you look inside, all you see is a cat. Now, is it logical for us to assume that the cat ate the mouse? Well, yeah. Is that reasonable? Yes. But then, members of the jury, the cat moves over a little bit, and you see in the corner of that box a hole. That hole represents reasonable doubt. The prosecution's case today is full of holes. They have to give you proof beyond a reasonable doubt. Because you can't just drag somebody like Sean Appleby into this court and charge them with murder and threaten their freedom without proof. But there's simply too much that is unaccounted for, unexplained, and unknown. Too much unknown time to convict Sean Appleby for this crime. Prosecution failed to explain a 9-hour window of reasonable doubt. And that is why at the end of this trial, you must find the defendant, Sean Appleby, not guilty.
Madam, I have an accounting of time. Judge, pursuant to the local rules C1, I would request an extra minute and a half for rebuttal.
What did you say?
A minute and 26 seconds. A minute and a half, maybe 2. Thank you, Judge.
Addition to what you
Thank you. May I proceed, Judge? 9 hours, 540 minutes, and 32,000 minutes, or seconds. 9 hours, 540 minutes, and 32,000 seconds that this man laid face down in his pool, drowning, dead. He laid in this pool for that long time. The defense told you that was a pretty long period of time. And he laid there alone because the defendant left him there, drowning, dying, unable to breathe, for 9 hours, 540 minutes, 32,000 seconds. The defense told you this case was full of holes. So let's talk about what's in some of these holes. Fingerprints. The defendant's fingerprints on the murder weapon, the defendant's fingerprints on the laptop. Emails. Emails that show that the defendant was implicated in a federal investigation by Mr. Lawson. Testimony. Testimony of every single witness who took that stand and told you about the relationship that the defendant and Mr. Lawson had. The testimony of Mr. Roberts when he told you that the defendant was arguing about those emails. Members of the jury, we didn't have to fill the last hole. The defendant filled it for us when he started lying and changing his story, showing that he wasn't willing to help in this investigation. He wasn't willing to help Detective Wortham. He was trying to be evasive, trying to make himself look not guilty. But when you're guilty, it's hard to come up with a story as to why you're not. He tried 3 times, and he couldn't do it. At the beginning of this case, Ms. Kilday told you we were going to spell it out for you. And if you look at everything that was there, all the evidence and all the testimony that you've heard and seen, and you look at the fact that these men were drinking alcohol in this backyard for a long period of time, very drunk, and you combine it with the pool in Mr. Lawson's backyard that they were getting out of and getting into, and put that pool equipment, those pool poles there, murder weapon. You put all of that with the laptop, those emails that implicated the defendant. You put everything in this backyard. And in that backyard, you have the defendant and Mr. Lawson yelling about those emails. You're left with one name because all of the evidence points in one direction. All of the evidence went from that chair to that chair. That is proof beyond a reasonable doubt. When everything combined together points one way, that's proof. And because of that proof, we have met our burden. Because we've met our burden, the law of this state requires you to find the defendant guilty.
Submitted to the jury.
Okay, thanks everyone. You may have a seat. We're going to introduce our judges so that they may confer. Gracie, for just a moment.
We're first going to share some comments with you, and then we will announce our decisions. We decided to do that before to announce a decision after our comments, so that you still be here to listen to hear them. I'll begin here on to my right.
Well, wow, you guys are on your way to being great trial attorneys, and very, very impressive on everyone's part, and so much fun to watch. And I was telling my fellow justices, I don't think I've ever been as young as you are. So I'm very excited for all of you. I think that I practice mostly in appellate work, which is very calm and non-emotional work, which is good for me. I think as I watch folks do trial that one of the hardest things is to sort of balance the law, that sort of considered rational approach with what you have to do, which is kind of pitch also to emotion, make appeals to emotion. And for the most part, I think all of you struck that balance very nicely for very young attorneys. A couple of you, I think, were more there than the others of you. But as I look forward for you guys, I think that's something that I would continue working on, is how high do you want to begin, you know, at what level of emotion, what pitch do you want to begin at, and where do you want to end at? And making sure that it's not too high or too low on either end. That's just a continuing struggle. And as a woman in the profession, I can tell you that it's a harder struggle for us. And I think when we miss that mark, it gets held against us more. So I try always to give special gender-based advice, because it's not really a man's world anymore, but those things are out there. So I think that's something for you all to be looking at. One thing I noticed that really impressed me was you all used the well so nicely. I just felt very comfortable there. Had your exhibits and your demonstratives, knew what you wanted to do, but it wasn't just knew what you wanted to do. This was unfamiliar space to you, and you used it. That's something that as trial attorneys you get to do, assuming you have a judge who's letting you be out there. And I think it is immensely effective with jurors for you to be able to use your space as though it belongs to you. Very respectful of the other side. I'd love to give particular critiques, but I don't want to hold you forever. I will just give a shout out to Mr. Smith's closing. I liked it especially well. I thought you pulled your case together, your alternate theories of defense. Yeah, defendants do have to actually, they should walk in feeling like they bear a burden, and you guys did a good job of walking in like you understood that whether you do as a legal matter, you do as a factual matter, bear some burden. So very well done, and just excellent. I was very impressed.
Yeah, you're all very good. It was a pleasure to do this on a very nice Saturday afternoon in San Antonio. I'll give some specific comments, just because you probably want these, but it's going to be quick. I'll start with Elliot. You have a very good, easygoing manner that works very well. It's not informal, but it's comfortable. I thought your direct of the defendant was good. It flowed, it brought out the points you needed to bring out. You got in, you got out, you got it done. And then I thought your cross of that witness, Roberts, was pretty good. Also, you made your points with it. You didn't try to tear them to pieces. Kia, you have a very, very good courtroom presence. Very likable. I thought you did very well in the opening. I especially liked it when you said, the evidence is going to show 4 things. And then you went about saying what those 4 things were. That's helpful because you guys know the facts. You've been doing this for the last 2.5 days. The jury doesn't. They don't know where you're coming from. So if you can spell it out that clearly. Both of you had a lot of argument in your openings. But that's okay. You'll get used to it. That's sort of the way the problem works. And I thought your direct was good. I thought you did a real good job on the direct. The only observation I'd make is I'd cut back on the references to let the record show, let the record reflect. You don't have to do it all the time. That's a very minor. Kira, I thought that your direct was outstanding. Did a really good job using those exhibits. I felt that I followed what was going on. I could figure out what the investigator did. I had a good sense of what the scene looked like. It flowed very well. It was very clearly laid out. I thought that was very good. And again, I thought your argument had, your opening had too much argument, but I liked it. It was concise. You got in there, you didn't talk for as long as you could. Chandler, I thought your direct exam was very good. It flowed very well. It was easy to follow. I thought that your closing was also very good. Like it when you argue from the evidence. You go to the jury instructions. That's what a prosecutor needs to do. The court's going to read the jury instructions, and you're trying to tell the jury, this is why you're going to convict the defendant under the instructions as given by the judge, and let me help you run through this. It's very good, and that's very helpful. I thought the spelling out of the defendant's name was, but it's a problem, and it's okay. And my criticism on the cross was you were making your points with that witness. You didn't have to win them to win them. You got that he was not answering your question. You didn't have to sort of beat on him until he finally came around to okay, well, that's what I said. Because you didn't get any more out of it. So be alert to what's the point you're trying to get. You got it, and then move on to your next. Keep it going. But again, these are real minor. I just figured you guys put a lot into this, so I'll give you each a couple of points, and those were my observations. Good job.
Well, it's a real pleasure for me to share the bench with these very distinguished. And I join each of their observations, and the critique that you just received from this very, very experienced, highly regarded prosecutor, and he's one of the best. Circuit of 3 states, so I think I see a lot of DAs, and I've been around a lot of DAs. Been at the bar 53 years, so I've seen a few of them. But this is one of either the best. And start off with saying something about the bench. While you're trying a case to a jury, don't ever forget about the bench. The jury identifies with the judge. One side pushing them this one way, and one side pushing them the other way. The only person in the courtroom that supposedly is neutral is the judge, and so they watch how you treat the judge and how they respect the judge and so forth. This is not a criticism of your treatment of the judge. I thought you handled it well, but I want to reinforce that with you. Don't forget about the court in terms of what you're communicating to the jury, because everything in that courtroom is in some way communicating with that jury. Some lawyers, they get a jury in the box and this judge get out of my way, and they can be a little snippy when in the tensions of trial. Don't do that. Unfailing courtesy that's genuine is awfully important to an advocate. Some of the best trial lawyers that I know and have worked with and aren't against were unfailingly courteous. Now, they would take your head off, but it was with a razor, and it was polite. And so you do that, and you have to always unfailingly do that. That's my general observation about it. I thought that the other thing I would tell you is that as young lawyers, that, and you're beginning, I think, to see that a little bit, that lawyers, we train lawyers so much about in the case law. You don't even get the full dimensions of the case. You get a little snippet of a case, and you don't see the underpinnings of all that went with it. But and so you get to you read this case, you analyze this case, and you gain to think like a lawyer and so forth. Well, that's well and good. But then what happens is that facts actually are are awfully important. They're terribly important. Facts matter at every stage. They matter in the trial court, they matter in the appellate court, they matter in the Supreme Court of the United States. Facts. Most trial lawyers, a young lawyer, just tell me the rule, and what they're doing is finding the fact. One thing about a trial lawyer that separates them, the ones that are really good, from the practitioner, is they have a quality that, like Steven Spielberg and people, film writers have, is that they can look at a cacophony of facts, which is what you really see when the case is coming in, you're developing, it's a mess, and they see a narrative line. They see the story. We communicate with stories. I try to teach that way, but that's what you do. There is a narrative line in there somewhere. I liken it to taking an examination for eyesight, color eyesight. They go in, you look at this screen that's of pixels, okay, 1,000 pixels up there, and if you can see red, then you'll see a 5 up there. If you don't see red, you won't see it. Well, the trial lawyer has got a sense about where this case is going, and it may shift and will shift as it develops. But they are beginning to look at those pixels of chaotic facts, and they're seeing in there a narrative line, which is going to be the storyline at trial. You need to find that storyline almost in every case, because that's going to be your communicative vehicle to the jury and to judges. Judges are just really aren't that much more sophisticated in many ways than jurors. As a trial lawyer, I would never try anything to a judge I could try to a jury. There's a lot of reasons for that, and I won't have time to go into that, and they're not all complimentary of judges, I suppose. Now with 40 years on the bench, it just validates my intuitions as a trial lawyer. But there are reasons for that. But a lot of it has to do with the fact that you're getting a lay view, and that's the power of the jury system. And it's a collective view. It's not a single person, and that matters a great deal. So that said about facts, I want to say one thing come back to women in the courtroom, because this is a fairly, right now we see so many fine young lawyers who come in, they're female. When I was in law school, we had one young woman, period. And now there were 50% of the classes, they're practicing before us. My colleagues are female. But let me tell you, from what I see, there is a difference. And one thing I will tell you, and I have 2 grown daughters and several grandchildren and girls, and one thing, you talk too fast. I asked my daughters, I said, Ann, Tricia, why did you talk so fast? And she said, Daddy, we do because some guy's going to interrupt us. Okay, I give you that. But in the courtroom, and this is true of guys too, I'm picking on them, there's a tendency of lawyers also to, because you put a time limit, they're going to say everything up there very quickly, and it's a measured. Look at what the anchors on television that they want to have some gravitas. They slow up and they speak with a deliberate pattern and so what. Slow it down. For God's sake, you don't suffer from it. Get away from that California up tilt on the head. Every question is no, yes, 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 everything. I don't know where that comes from, but I've talk to people who are professionals in speech patterns and so forth, it is a very distracting phenomenon. And young women talk to each other that way, and you got to get that out of there. None of you had that problem, but there are others here, and just be careful of that. So you have a tendency to talk rapidly. The other thing to be real about is an awful lot of the judges are going to be people my age or hopefully younger, but they're probably going to have some of the disabilities I have. They've been in the military service, and one thing or another, they've done a lot of things that hurt their hearing. So they don't hear in the ranges in which women's voices appear. But there's a whole now study of it, where professional women are taking courses to take their voices not down to talk like a man, but to take a little to raise down why they want to do that, because they found that they present themselves and they're given more credit. They're not interrupted. So just those little things matter.
I should just add that the last time I argued in front of Judge Higginbotham, I wouldn't expect him to remember, but he did in fact tell me to slow down. So.
Well, and it's difficult in an appellate argument, particularly or any of these arguments. In an appellate argument, at the outset, you got a lot at stake, and you're nervous. I don't care. Chief Justice Roberts, who argued more cases before the Supreme Court than anybody else, is Daniel Webster. I know I was with him, and the student asked him, said, "What did you get nervous before your argument?" He said, "The last argument I made before the United States Supreme Court, I went in the restroom and threw up just like I did before every other argument." So you're going to have nerves, but don't translate those into rapid speech. Has been my own family comment about that. I found in general that all of you have qualities that will serve you well in the trial of cases. I hope that we still have trials in meaningful terms. That's another phenomenon that I'm not happy about. But you are doing the right track, because there are a lot of skills that you can acquire, the basic skills. The other thing I will tell you is take every opportunity you can to watch a very seasoned trial lawyer in operation. I was blessed with mentors and a very young lawyer to see them in operation and to learn from watching, because you can learn a lot. I guess the time pressures keep people from going down to the courthouse and watching a case being tried anymore, but I always managed to find some excuse to get into the courthouse as a young lawyer. I'd go see Percy Foreman when I found out where he was, one of the best cross-examiners I've ever seen, a criminal offense lawyer. So anyway, I would encourage you to do that. I think we're always going to need trial lawyers. I think they're moving in a different direction toward boutiques and so forth. But if that's your inclination where you're going, I think all of you have the skill set to do that. I would finally say that this competition is a real opportunity for you. It's put together by people who are awfully good. Professor Sluter writes these problems, and they're just outstanding. I've done a lot of these things with other places. This is the best in terms of all the things that's run. St. Mary's does a wonderful job with its clinical programs and its trial programs and so forth. Trials put your training together. I mean, clinical programs are not some secondary effort. That makes you put it all together. You got the cases, and you see it in working, and it does in your meaning and so forth. I congratulate each one of you on being here. All of you are winners to be in the final round of this. You're absolutely so. Unfortunately, we have to make a decision about that, and I will tell you that it was infinitely close. And I won't tell you how close, because you'll be second guessing yourselves, and that won't do. It's like the guy that misses the point after touchdown when he gets blamed for everything when something else has happened. But anyway, what we finally concluded, and we're asked to choose the quote winning team and the best speaker today, and we have done that. And then it's close. We finally concluded that the team to win was the prosecution. and that the best speaker here was Elliott Smith. Thanks.
Congratulations to you all. We have our first present and the finalist for our final. Special thank you to our wonderful. This mock trial competition. I'd like to thank the members of the board